favour? Appeal in the matter of Brookhouse Group Limited and Lancashire County Council.
Mr. Williams.
Please, your lordships, your ladyship, I appear together with Mr. Tom Walker on behalf of the appellant in this matter, Lancashire County Council. The respondent, Brookhouse Group Limited, is represented by Mr. Tim Bewley, KC, and Mr. James Neal. This appeal concerns whether the respondent's claim for a declaration of ineffectiveness in a procurement matter is time barred pursuant to Regulation 93 of the 2015 Public Contracts Regulations. The submissions I intend to make will follow the following course. First of all, I'll set out the background, including the dispute and the present appeal, and then address the central question that we say the court needs to address. Turn then to the relevant provisions of the Public Contract Regulations, with reference to some of the other regulations as well. Then our submissions on ground 1, then the grounds of appeal, and then finally our submissions on ground 2. Turning then to the background, the parties' dispute concerns the development of what is known as the Cuerden Strategic Regional Investment Site. It comprises some 65 hectares of land and is in fact the largest single employment site in Preston, South Ribble in Lancashire, and the Lancashire City Deal. The appellant owns some 71% of the site, whilst the respondent owns parcels amounting to about 29%. There is some residential property in private ownership too. On the 8th of March 2012, the appellant commenced a competitive tender procedure for the development of land under its ownership by publishing a contract notice in the official journal of the European Union. And the details of that's referred to by the witness statement of Mr. Steve Burns on behalf of the appellant at paragraph 11. But it's worth looking at the contract notice, which is in the supplementary bundle at tab 2, page 7. This is, in our submission, typical of the sort of contract notice that would have been published under the auspices of the European Union at the time, in 2012. Contract notice, that's advertising that there is to be a contract or contracts awarded by a competitive tender. Over the page on page 8, we see under type of contract, there was to be a works contract. One of the definitions of works being realisation by whatever means of work corresponds to the requirements specified by the successful tender. Section 213 points out that the notice involves a public contract. There's then quite a long, short description of the contract, construction work effectively. Over the page, onto page 11, you see that the contract was split into 2 lots. They were geographical lots. We're concerned with lot 2.
Sorry, page 11.
Yes, sorry.
Yes, I see.
And your lordships will see that the lot title for lot 2 was Lancashire Lot 2 Partnership. Now that included a number of areas within Lancashire. South Ribble is where this site is located. We see under section 3 towards the bottom of that page the estimated value of the council property assets for that lot was in the region of 160 million. Over the page again to page 13, type of procedure of section 411, the competitive dialogue. I should say that's one of the procedures where tenders are not immediately invited, but there's an opportunity to express interest, and then candidates can be invited then to submit tenders, and then there's a dialogue leading to the award. You see the award criteria there. Important for our purposes is section 434, the time limit for receipt of tenders or requests to participate was given as 10 o'clock on the 12th of April 2012. And over the page under additional information, section 6.3 towards an end, there's a paragraph that starts, expressions of interest must be received before the deadline in order to qualify as being in time. As such, bidders are urged to submit their submissions well in advance of the stated time or dates in order to avoid such issues as technical difficulties with the electronic system, maybe due to high volumes of traffic attempting to submit applications on the same date at the same time. Expressions of interest delivered after the date and time specified or to different address, electronically or otherwise, will not be considered under any circumstances. And we see over the page on page 15 that notice was dispatched for publication on the 6th of March 2012. The contract was quite well advertised. It had been preceded by the publication of a prior information notice. That just gives advance warning that the contract notice is going to be published. The appellant's aim was to procure, as we've seen by virtue of the two lots, two regeneration property partners who were to join with the council to work with also with the Lancashire Enterprise Partnership and other Lancashire organisations to deliver comprehensive regeneration across Lancashire through the structured development of its public sector assets. The contract between these partners and the appellant was to be for an initial term of 10 years, commencing in December 2012, but there were options for that to be extended, in fact, for a further 10 years in two increments of 5 years. Again, Mr. Burns explains that at paragraph 13 of his statement. Now, I've already indicated that procurement was to be conducted using the competitive dialogue procedure. It's important to note, however, that the respondent did participate, or rather attempted unsuccessfully to participate in this procurement, because it failed at the first hurdle, as Mr. Burns explains at paragraph 14 of his statement. The reason for that was, as I've already shown your lordships, the deadline for receipt of requests to participate was 10 o'clock on the 12th of April 2012. In fact, it wasn't until the 30th of April, after the expiry of that deadline, that the respondent wrote to the appellant to express his interest in the competition. And as the specified deadline has passed in accordance with the tender rules that I've just taken your lordships to, the appellant informed the respondent on the 21st of May that its tender could not be considered any further. That's Mr. Burns at paragraph 14. On the 6th of December 2012, two contracts were awarded by the appellant following the conclusion of the competitive dialogue procedure. No challenge was made to either of them, and a contract award notice was duly published on the 7th of January 2013. That's found at tab 4 in the supplementary bundle, at starting at page 97. For present purposes, it's worth noting on page 99, that it was a works contract, that's section 212. For 213, you'll notice that neither box has been ticked for whether the notice involves the establishment of a framework agreement or...
Sorry, I wasn't keeping up. Where are you?
I'm sorry. Page 99.
Yes.
I do apologise for racing that off. Page 99, section Roman 213.
Yes.
And what I'm drawing your attention to there is that the lack of any ticking of the box. The notice involves the establishment of framework agreement. The notice involves contracts based on a dynamic purchasing system. If we turn over to page 103, we see confirmation that the type of procedure used was the competitive dialogue. That's section 411. And over the page again, page 104, you see information about the award of the contract. Lot 1 was awarded to a company called Carillion Construction Limited, alas no longer in being. But on page 105, we see that lot 2, that's the relevant lot, was awarded to the Eric Wright Group, section 5.3. and that the award decision was taken on the 6th of December 2012. That's just a verdict. See confirmation that the value of the contract was 140 million at section 5.4, and over the page on page 107, the date that it was dispatched and published in the official journal, the 7th of January. The contract that was then relevant to proceedings was awarded, as I've said, under Lot 2 to the Eric Wright Group. It was entered into between council and that developer on the 20th of December 2012, and it's known as the Strategic Partnering Agreement. We see a copy of it, albeit redacted, at tab 3 in the supplementary bundle. Very wide in its scope. Perhaps the only provisions I'd like to take the lordship to at this point. Page 34, we have a provision, a clause rather headed.
Redactions arise because
They, before proceedings were started, there was an agreement between the parties that both this agreement and the development agreement that is challenged could be disclosed to the claimant into a confidentiality ring, or rather under a confidentiality agreement, but with certain redactions in relation to commercially sensitive information in the agreement.
right. So there's a confidentiality ring.
No, it's
This is the non-confidentiality ring version, isn't it?
Yes, I mean I'm assuming that the redactions are as it were agreed and contain commercially sensitive information.
yes.
So we don't have to worry about
That-
judgments referring to anything that we see. We can refer to.
Yes.
Yeah.
I was referring also to clause 9. 9.1 says EWG will be granted exclusivity in relation to any new project which becomes a stage 1 approved project as provided in clause 9.2a. So that may be lost in respect of any property covered by a new project which has been properly rejected by the authority at stage 2 approval as provided in 9.2b. Then there's a heading approved new projects, and over the page we see at 9.2a. If a new project is approved pursuant to the new project's approval procedure set out in Schedule 3, thereby becoming an approved project, then EWG will have the right itself or to nominate one or more project companies to implement the approved project and to enter into the relevant project agreement or agreements in relation to that project. So we describe the SPA as a framework contract. That's not really a term of art. It wasn't a framework agreement or awarded under the regulations, but it did provide a mechanism by which the applicant could enter into further contracts within its scope for the development of the Cuerden site. That's disputed between the parties, and that's the substantive issue for trial, should limitation not avail the defendant. Now, in 2019, the parties attempted to agree on heads of terms for an agreement between them for the further development of the land. That's the land at 29% belonging to the respondent on the site. However, in a letter dated the 15th of January 2020, perhaps it's worth turning this up as a tab 5 in the supplementary bundle. It was explained by solicitors acting for the appellant that the appellant's preference was in fact to execute the terms of the SPA that I've just taken lordships to enter into development agreement with EWG in accordance with the provisions of clause 9.2a of the agreement. And you'll see that's set out in paragraph 4, where it said 4 lines down, as you're aware, our client has an existing framework arrangement with Eric Wright Group Limited, under which our client may enter into development agreements with EWG for the development of any land owned by our client. And it goes on to say, as the framework agreement with EWG was procured in accordance with the 2015 regulations, in fact, they would have been the 2006 regulations at the time, our client can enter into a development agreement with EWG that contain binding obligations on EWG to undertake works in accordance with our client's specific requirements. There then followed a series of correspondence between the parties in which the respondent contested the appellant's entitlement to award a contract under the SPA. The tab 6 is the first of these. That's dated the 13th of February, and you'll see from page 120 that issue is being taken with the procurement process and the validity of the framework agreement.
Hang on a minute.
Which paragraph?
Paragraph 2.1 deals with the procurement process.
The MOU to which they're referring?
There was, yes, the MOU, there was an agreement between the parties in how they would deal with the possibility of the parties agreeing to develop the respondent's land. That's a separate agreement. That's a memorandum of understanding. There was a dispute as to the terms of that, but that's between the respondent and the appellant. But here,
That related to the development of the respondent's land,
yes.
right?
But here, in paragraph 2, and indeed 3 as well, the respondent is taking issue with the entitlement of the effectively to terminate its agreement with the respondent, and instead to pursue development of course, its own land, 71%, with Eric Wright. It says in paragraph 2.1, 2 lines down, entirely without prejudice to our contention set out above by the MOU, Lancashire County Council as a public body conducted what it calls an informal procurement process with BHG and Eric Wright Group. BHG made it clear throughout its participation in that process was entirely without prejudice to its position under the legally binding MOU. The respondent's position was that it already had a contract with Lancashire County Council, and the council wasn't entitled simply to walk away from it and treat with Eric Wright Group. There can be no doubt that the seeking of proposals from BHG and Eric Wright Group of itself represented a comparative process, albeit Lancashire County Council chose to limit the participants to BHG and Eric Wright Group. And then the last sentence of that paragraph, instead it seems LCC appears to have assumed that having discounted BHG, it could then instead revert to appointing Eric Wright Group under a pre-existing framework agreement, that's what it calls it, with no meaningful attempt to test the market. And then in section 3, paragraph 3.2, without prejudice to our above contention that our client has conducted an unlawful procurement process, we note in paragraph 4 of your letter, that's the one on the 15th of January, you refer to an existing framework agreement with Eric Wright Group Limited, which you assert was procured in accordance with the public contract regulations. The only record we have found of any such agreement is the contract was procured by Lancashire County Council in 2012 for a 10-year framework agreement with options to extend for a further 10 years at 5-year increments. And therefore I'd ask confirmation that that is the agreement that was being pursued. Perhaps it is worth looking at this chain of correspondence. Then over the page on tab 7, the letter of 13th of March in response.
Well, tab 7 is important because that's the letter of the 13th of March, which is expressly referred to in the reply to the letter of claim. So if we have to get into reasons, this is expressly relied on.
Yes, my lord. This, I mean, we say it's one of a number, but yes, this is.
Yeah, but this is the one that's expressly referred to in the council's response to the letter of claim, which is the 22nd of September 22, yes. And first paragraph says, blah, 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 notably by the letter dated 13th March 2020 sent to you by our solicitors. So that's why I flagged this up.
Yes, and I therefore will take your lordships to what I said here. Bottom of page 124, procurement process. We do not agree or accept that our client was conducting the informal procurement process with your client and Eric Wright Group. Over the page, our client has a strategic partnership agreement in place with EWG, details of which are set out in paragraph 3 of this letter, for the delivery of comprehensive regeneration across Lancashire through the structured development of public sector assets. As the development of the site falls within the remit and scope of the SPA, our client engaged with and sought a development proposal from EWG pursuant to the terms of the SPA. 2.4 says our client has never suggested that this was a market testing exercise, that it's dealings with EWG, BHG, as purported in your latest letter, and our client does not accept that it should have or was required to open up the development of the site to other parties through a procurement exercise. Our client engaged with EWG pursuant to the terms of the SPA, which was properly and legally procured. Our client engaged simultaneously with your client to determine the potential development options available with your client. Our client was well within its rights and acted properly and lawfully in doing so. And then paragraph 3, framework agreement with Eric Wright. Our client entered into the SPA with EWG on the 20th of December 2012, pursuant to its powers contained in Section 1 of the Localism Act of 2011, having conducted a procurement exercise in accordance with the Public Contract Regulations of 2006, they were the ones that were in force at the time, initiated by the issuing of a contract notice in the Official Journal of the European Union on the 6th of March 2012. This appears to be the same procurement that you refer to in paragraph 3.2 of your latest letter. Crucially, however, the SPA is not a framework for the purpose of the regulations, and it was not procured as one. It is a long-term strategic partnering arrangement for the structured development of the public sector assets in Lancashire. One of 2 such strategic partnering agreements procured by our client at that time. The response to that then is at tab 8, the 24th of March. Again, after a section dealing with the Memorandum of Understanding, section 2 on page 128, where the respondent comes to deal with and take issue with what he calls the procurement process. And I'll just take your lordships on page 129 to paragraph 2.4, where it says, it follows that we are clear that if Lancashire County Council in any sense takes this matter further and concludes the contract with Eric Wright under the auspices of this arrangement, then that will be an unlawful direct award which can be set aside for ineffectiveness and will be open to challenge by Brookhouse Group and or any other economic operators who will have been unlawfully excluded from the opportunity to tender for such contract. And we say that is significant.
You say that's significant because that's their claim now.
Yes. But it also indicates what it is they would have wanted to do in relation to the development agreement, which comes in just over 2 years' time.
Yeah.
The respondent, there is a little bit more correspondence, but the respondent subsequently made a freedom of information request with details of each development contract that had been awarded using the SPA with EWG, and in fact Carillion for that matter. And on the 15th of February 2021, in response to that request, the appellant provided the respondent with details of 11 such projects, and that included one in relation to the Cuerden site. You see that at Supplementary Bundle tab 12. This is an email which takes in place both the request and the response. So you'll see after the word request, it is set out what it was that was requested, including bottom 1, basic details of each order placed or contract awarded to the relevant contractor under each lot, identifying the site or project and the nature of the work or services to be provided, the date of each such order award, and the estimated or completed total cost of each contract. And then after that is the council's response. Please see the table which shows the information you are seeking. The project sites, purpose and the dates provided are the relevant dates when the initial stage of the schemes have been considered. Please note the amount paid to the partner may include costs paid for work undertaken by external consultants or contractors. There are approximately 100 sites or potential projects that have been appraised by the two partners in the DWG. To some degree, as part of the review of potentially surplus sites of the County Council that have not reached the stage where there were financial payments to the partners, and therefore these have not been included in the table. We see lot 1 first of all, then lot 2, there are 11 projects, the 1, 2, 3, 4, 5, 6, 7th, that's on page 138. You'll see South Ribble, Woodland Strategic Site, development of site on the 18th of December 2018, a figure of just over £250,000, and a condition initial costs agreed up to 1.6 million, LCC contribution to 800,000. Obviously, that's work that preceded the development agreement.
So that is a contract let under the SPA.
Yes, my lord. No, it's not that one that the respondent challenges.
No, because we haven't got to that yet. But that's a previous contract
Yes.
let under the SPA.
They are all under the SPA. The last 11 are under lot 2 of the SPA. I highlight that one because it's actually in relation to the site that we're now, because as your lordships can see.
Okay, so it's a previous contract let under the SPA and relating to this site.
Yes. Ultimately, the appellant entered into the development agreement that the respondent does challenge with Maple Grove, that's a wholly owned subsidiary of EWG, that was permitted under the SPA, through the execution of the terms of the SPA, and it did that on the 29th of July 2022. And we see that at tab 13. Again, this is redacted. There's probably not much that we need to look at in this. It's accepted that this is a works contract. Schedule 5 on page 206 sets out the development obligations. This is the agreement that the respondent says should have been competitively tendered and that it would have wanted to bid for. On the 3rd of August, so just a few days later, 2022, the appellant notified the respondent that it had entered into the development agreement with Maple Grove, and that fact was accepted by the respondent, Mr. Scott's witness statement at paragraph 5. Given the repeated challenges to the legality of the SPA, I've taken lordships to some of those already in the correspondence, the appellant was concerned that the issuing of a contract award notice in respect of the development agreement would probably prompt an immediate challenge from the respondent, or indeed by any other would-be tenderers. That's what Mr. Burns explains in paragraph 17. In any event, because the entry into the DA, the development agreement, was simply the execution of the terms of the SPA, the council, the appellant, did not consider that as a matter of law a contract award notice was necessary. Accordingly, none was published. Instead, there followed a further period of correspondence between the parties. There was a press release at tab 14 on the 2nd of September, which advertised the fact to the world at large that plans had been submitted for key employment site in central Lancashire. And if you lordships see at page 15, there's a
15 of
tab 15, page 221. There's a round robin letter, I suppose, expressly stating that I wish to write to you, update you on the proposed development of Lancashire Central site at Cuerden. Following consultation, a planning application has been submitted. and so forth. It's intended that there should be 116 homes contribute to supply of new homes. And if your lordships turn over to page 223, you'll see that that copy of that letter was sent on the 2nd of September to Brookhouse Group Limited, you can see from the email address. On the 8th of September 2022, so just a few days later, Brookhouse sent a detailed letter before claim to the council. That's at tab 16. At the last mention, it's clear from this that Brookhouse fully understood what it had been told already in relation to the development agreement. It took issue with that. Its argument, I think it's fair to say, is no longer that it was an impermissible framework agreement, but it certainly does allege that it was entered into in contravention of the then enforced 2015 public contracts regulations. Paragraph 4.9 on page 230, it says, therefore, our client has reason to believe LCC has both awarded and then entered a contract for public works above the threshold without any prior public notification or regulated procurement competition. Subject to consideration of your response and any further relevant information you provide, our client will therefore seek a declaration of ineffectiveness, which should be under the first ineffectiveness ground in regulation 99(2) of the PCR. And they sent a schedule on page 232 with a whole host of documents, effectively the correspondence going back and forth between the parties. And we see on page 233 at line 27, there's reference to the Planning Commission press release that I took your lordships to. The council provided its response on the 22nd of September, tab 17. This is quite a detailed letter setting out why the contract had not, for the development agreement, had not been tendered and why the council was entitled to do that. Can I summarise the letter by saying it confirmed the conclusion of the development agreement. It provided Brookhouse with a, frankly, very detailed summary of the reasons why the council was entitled to enter into the development agreement by the execution of the provisions of the SPA without conducting any further tender process. And it also provided details of the SPA and the development agreement itself. By reference to clauses within the agreements which entitled it to do that. Brookhouse replied by letter of the 4th of October, that's tab 18, in which it confirmed, effectively, it understood the council's position in relation to the SPA and DA. It contested it, but it confirmed it understood the argument the council was making. And it reiterated its view that the development agreement should be set aside as ineffective under the 2015 regulations. So on page 246 we see third paragraph, having reviewed your letter and despite not seeing the documents we requested in our letter and saying we now have a clear understanding of your position. It then sets out over the page 7 overview of your defence, a summary of what it understands that to be. And then goes on to describe an application for a claim for a declaration of ineffectiveness and the implications of that, and makes requests for disclosure. And further to that, draft particulars of claim were provided to the council by Brookhouse on the 21st of December 2022.
Right, for what it's worth, I see at the bottom of 249, they're flagging that it's their position that they have a number of months to commence proceedings.
That's a position they've maintained ever since.
Yes.
Yes.
And so, sorry, the draft particulars of claim was sent on.
That was sent on the 21st of December. A copy of it is at tab 20. The council, just prior to that, on the 18th of October, tab 19, had said, in relation to your comments on disclosure, paragraph 4 of the letter, the council are not averse to providing redacted versions of the development agreement and the SPA as requested. And that disclosure and confidentiality agreement is then found at tab 21, dated the 22nd of December. Of course, even before receipt of that, and copies of the redacted versions of the agreements which were disclosed, the respondent has already been able to provide its draft particulars of claim, which materially are the same as those that then subsequently came with the claim when it was issued.
So what it's worth at this point, on your case, they're absolutely up against the deadline.
Well, the point that I'm trying to make through going rather laboriously through this is that the very shortly after the 29th of July 2022, the respondent knew that the development agreement had been entered into. Even before that, but certainly very shortly after it, it knew full well what the reasons were that the council had done that, why it hadn't conducted a competitive tender procedure, which would have allowed, as the respondent says, it to participate, and why it was justified in so doing.
And I follow all that.
Yes.
And I don't think this really matters, but you say by the 22nd of September you'd supplied enough.
Yes.
And so the 30 days ran to...
For some reason, it starts on the day after. So it starts from the 23rd and would have expired 30 days later. Yes.
which would be rough.
I'm going to take your lordship to the...
But the order of the 18th of October, when you write your letter at tab 19.
The crunch letter is at tab 17. Is that right, Williams?
Sorry, the...
I said the crunch letter is
Yes.
at tab 17.
I mean, I have to say, in fact, most of the information contained in here, this is clearly much more than a summary, had already been provided before that date. But yes,
Well, your pleading case is that
yes,
no later than that letter.
I think I take your lordship's point in relation to our letter on the 18th of October. Whether that's by accident or design, I know not. I don't think that's quite 30 days, actually. But
It'll be almost 30 days anyway.
on the 20th of January 2023, the respondent then issued its claim. That's, of course, in the core bundle. You can turn it up, it's at tab 9. There's a brief appendix of brief details of claim at page 106, and then at page 108 onwards, the particulars of claim, which are effectively the same as the draft that we'd received previously. In its defence, which is at tab 10 in that bundle, dated the 16th of February 2023, the appellant denies the respondent's allegations in their entirety, but it also included, for our purposes, paragraphs 21 to 25, page 1 through 4, its limitation defence, pleading a limitation of 30 days pursuant to regulation 93.5. And I'll take your lordship to that in just a moment. The respondent subsequently made an application to strike out.
Just to anchor it, the council's primary case is that the public contract regulations don't apply.
Yes, to the development agreement award.
So that the claim is misconceived on the council's case.
Yes.
So for the purposes of the strikeout, we are assuming that what, the council are wrong about that? Because it's a slight oddity in this case that you're relying on provisions in the public contract regulations which you say don't apply.
Well, the claim has been brought by the respondent under the public contract regulations. Well,
So
all
for
right.
our purposes, are we to assume that for the purposes only of this issue, the public contract regulations do apply?
Oh, my lord, yes.
Yeah.
I
I mean, you're
Councillor-
quite right to say, paragraph 21 is very clear. It says the claim is brought under the public contract regulations. But this paragraph comes after quite a lengthy section which explains why the public contract regulations don't apply at all on the council's case.
My lord, yes.
So we assume that the public contract regulations apply to this claim.
Yes, to the award of the development agreement as the respondent would have it. In our submission, we are entitled to run these two parallel defences. That's right, I think I said the respondent subsequently applied to strike out the limitation defence. And thereupon we cross-applied to strike out the claim in its entirety, or alternatively made a claim for summary judgment on the basis that the claim was time barred. Those applications were heard together by Mr. Martin Bowdry, KC, sitting as a Deputy High Court Judge on the 17th of October last year. His order is at tab 6 in the core bundle. And your lordships will see that he granted the respondent's application and thus struck out paragraphs 21 to 25 of the defence. Consequently, of course, our cross-application had to be dismissed and was. The key findings of the judge in coming to that order are the judgment at tab 7, and the key findings in that, in fact, it's quite a long, well, it's not that long judgment, but it's paragraphs 30 and 31 which are the crux of the matter. That's at page 97 and 98. For he
30
found,
and 31, is this fair? 30 and 31 is the judgment.
yes,
I mean, there is nothing else once you take out the background
yes,
And,
there's
uh,
quite a lot of.
and the PCL.
The key findings then were that the time limit provided by Regulation 93.5 only applied where there had been a competitive tender exercise, and of course in this case for the development agreement there hadn't been. That's at paragraph 30. And at 31, that the appellant had not provided the respondent with a summary of the relevant reasons within the meaning of Regulation 55. Effectively, again, because there hadn't been a competitive tender, so the appellant was not in a position to provide the relevant reasons in respect of a competition. And for those reasons, therefore, the respondent's application succeeded. Permission to appeal, of course, was granted by my Lord Justice Coulson on the 20th of March 2024. That is in the core bundle, tab 1. I think the only point I would make at this stage, there's a caveat at the end of this, paragraph 5, in which your lordship says, I note that the judge did not refer to, and presumably was not taken to IGT and the Gambling Commission. Maybe it's wholly inapplicable to the issues of the appeal, but since that case was concerned with who can and who cannot make a public procurement challenge, it may well be of relevance. That authority was cited, and I believe it was in the authority's bundle.
We refer to it in our skeleton, right?
Yes.
I can't remember what saying.
As it turned out, I don't
I
think.
think it would be fair to say that neither of you have it anywhere close to the forefront
No,
of your
that's right.
respective arguments. You didn't then. I make it quite clear that it seemed to me that it might potentially be relevant. So far, on my reading of it, it is unlikely to be of any relevance, because what we're concerned with here is a situation where there has not been a competition, and therefore all those considerations as to the remedies directive and so on in IGT don't arise. That on the face of it, that would appear to be the case. So you don't, at the moment, the skeletons don't go into IGT in any detail, and I'm certainly speaking for myself, I understand why.
Well, my lord, without wishing to disagree, I do intend to make submissions on the basis of that case. There are some, I hesitate to call them nuggets, but there are some very interesting. There's very interesting
nuggets. I doubt whether there are nuggets, Mr. Williams, but there may be the odd bit.
Well,
Fine.
in relation to the definitions of tenderer, but more importantly, candidate, and the consequences of being a candidate and what that entails. In our submission, it is a judgment, therefore, that's worth being looked at. Anyway, the central question for the court, we say, and I think there's nothing between us on this, is the question, does Regulation 93.5 of the 2015 regulations apply only where there has been a competition in respect of the challenge contract, or can it apply to what we term would-be candidates, that is, economic operators who would have wanted to participate even in the absence of a competitive tender procedure? Do you want me to read that out again? Or?
No, not myself anyway, I don't know.
Right, the relevant provisions. The 2015 regulations are at tab 5 of the authorities bundle. First of all, some definitions which are in Regulation 2. We have at page 42 the definition of economic operator. They're all listed alphabetically here. Economic operator, it says, means any person or public entity or group of such persons and entities, including any temporary association of undertakings, which offers the execution of works or a work, the supply of products, or the provision of services on the market. That's clearly a very wide definition. Then there's a definition of candidate, page 41. Candidate means an economic operator that has sought an invitation or has been invited to take part in a restricted procedure, a competitive procedure with negotiation, a negotiated procedure without prior publication, a competitive dialogue, or an innovative partnership. There is then also the definition of tender at page 44. I have to say there was a lot of discussion of this, for instance. It is not our case that the respondent was ever a tenderer. It is our case that it was a candidate within the meaning of the definition. But for what it's worth, tenderer means an economic operator that has submitted a tender. Lordships recall it didn't submit a tender in 2012 because it was too late, and in 2022 it didn't submit a tender because it wasn't invited to do so. There was no competitive tender procedure.
There is no issue but that the respondent is an economic operator. Let's leave aside candidate and tenderer. It's agreed common ground?
From our point of view, yes, it must be. Now, the special time limit for a claimant seeking a
Just before you
declaration.
go on, so you accept you're not a tenderer.
Except they're not a tenderer.
Sorry, you
Yes.
accept they're not a tenderer. But you say they are a candidate
Yes.
because
Because, well, according to this definition,
yeah,
they sought an invitation. They were never invited to take part, but they sought an invitation.
In relation to recent events or 2012 events?
We say both. I don't think even the respondent would argue that it wasn't a candidate within that definition in 2006, albeit the definition was different.
For the avoidance of doubt, we certainly do say we're not a candidate, but I don't want to go into detail on it.
no, well,
We might have been a candidate in 2012. We weren't a candidate in 2022.
Okay, so anyway, you say, Mr. Williams, that Brookhouse were a candidate both in relation to 2012 and 2022
Yes,
because they sought an invitation.
yes. I think the point we would make is that it is possible to seek unsuccessfully an invitation, and you're still seeking an invitation and you're still a candidate. You are someone who would have wished to be an entity to whom the contract would be awarded, and I'll come back to that phrase. But first of all, Regulation 93, which is at page 77 in that tab. I think we set this out in our skeleton argument, paragraph 31 as well. First of all, it says 93.1. This regulation limits the time within which proceedings may be started where the proceedings seek a declaration of ineffectiveness. 2, such proceedings must be started A, where paragraph 3 or 5 applies within 30 days beginning with the relevant date mentioned in that paragraph. B, in any event within 6 months beginning with the day after the date on which the contract was entered into. Now, paragraph 3 covers a situation where a contract award notice has been published. It's common ground between us that there was none, so this simply cannot apply and does not apply. But paragraph 4 gives more information for that purpose. Paragraph 5, however, states, this paragraph applies where the contracting authority has informed the economic operator of A, the conclusion of the contract, and B, a summary of the relevant reasons, in which case the relevant date is the day after the date on which the economic operator was informed of the conclusion, or, if later, was informed of a summary of the relevant reasons. And then 6, in paragraph 5, the relevant reasons means the reasons which the economic operator would have been entitled to receive, I stress the tense there, in response to a request under 55.2. I'll take a look at 55.2 in just a moment.
And just seeing whether we can cut to the chase. Really, does everything turn on what 93.6 does?
Yes, I mean that's the way that the learned judge found it, but it could only apply to where effectively, and I think he uses these words, the reasons the economic operator was entitled to receive.
Yeah.
Accordingly, then, when a declaration of effectiveness is sought, there's either a 6 months time limit, or unless Regulation 93.3 or 5 apply, in which case it's 30 days. And as I've already said, there was no contract award notice in this case, so we're looking at 93.5 and 93.6. As to the meaning of relevant reasons, as you've seen, Regulation 93.6 refers us to Regulation 55. That's at page 64 in tab 3. And that states, on request from the candidate or tenderer concerned, the contracting authority shall, as quickly as possible, and in any event within 15 days from receipt of a written request, inform A, any unsuccessful candidate of the reasons for the rejection of its request to participate. Now, I won't read B, C, or D because that only applies to a tenderer, so it's common ground, it doesn't apply. But we say 55.2a does, because the candidate was an unsuccessful candidate, the respondent I should say, and it was given the reasons for the rejection of its request to participate. Turning then to...
Just pausing there, does your case depend on Brookhouse being an unsuccessful candidate or not?
Well, it depends on it being a candidate. It is surely common ground that it was unsuccessful.
Yes.
It was never invited to participate and was never invited to submit a tender.
So just to be clear, on your case, it is crucial that Brookhouse was a candidate.
Yes.
Why? Why does Brookhouse have to be a candidate? Why can't Brookhouse be an economic operator, which would still, on one construction, bring it within 93?
Because it was argued at first instance that there is a subcategory of economic operators. And this is where I think that the decision in IGT is very helpful at breaking it down. Only certain categories of economic operators are entitled to, for instance, bring a claim or entitled to ask for reasons for rejection. Now, as I will make submissions, it doesn't have to be someone who actually even attempted to participate. But it does cover economic operators who do attempt to participate, and we say that that covers the situation of the respondent.
Sorry, say that again. It doesn't have to be someone who doesn't participate.
Who seeks to participate.
It doesn't have to be someone who seeks to participate.
Yes, it can be someone who would have wished to participate, but was unable to do so. My lord, the Grossman exception that your lordship refers to, IGT, that I'll come to. Thus, for instance, it is
Leave aside the Grossman exception, the first ground of a declaration of ineffectiveness under 99 is where there's effectively envisaged a situation where an economic operator simply didn't know about the competition. And they can obviously, such an economic operator can obviously bring a claim under the regulations. So then the question is whether, but you say, well, yes, they can make a claim, but for the purposes of when the time limit is, do you accept that in order to trigger the 30 days, they've got to be more than an economic operator?
Oh,
It's got to be a candidate.
well, and they have to be provided with certain information, and that information must include the fact that the agreement's been entered into, the agreement that they challenge, and the summary of the reasons why their request to participate was rejected.
Yes. So an economic operator who doesn't know anything about it can make a claim, but do you accept that in those circumstances that's the 6 months?
It would be, unless 93.5 applies. 93.5 will apply if that economic operator, being what we call a would-be candidate, is provided with the information in 55.2, 55.2A.
But then they would be a candidate.
Yes.
So if it's an economic operator, they don't know anything about it and they have 6 months. If it's a candidate, then they get 30 days from the date at 50 when they get 55.2A.
My lord, yes, your lordship says they don't know about it. I mean, obviously, one of the pieces of information they need to be given is the fact that the agreement's been entered into. So then they will know about it. They may not have known about it beforehand.
No, the reason that I'm starting that far back is because, as you know, the European Court have said the most serious breach of public procurement law is where there's a direct award. And when you have a direct award, it's not, the economic operator doesn't necessarily know about it. I mean, there are some people who say 6 months is too short, but that's why 6 months is the outlier otherwise all these incredibly tight time periods, because if that happens, there's no reason necessarily why the economic operator would know about the competition. And in those circumstances, you don't get into 93.5, even A, because the contract's been awarded and they simply don't know. And then they find out about it, and then they bring a claim within the 6 months. But you say that's fine for an economic operator who doesn't know anything about it. But if it's a candidate, then you say it's 55.2A.
My lord, yes. the very existence of the first ground of ineffectiveness presupposes a case where obviously no contract notice was ever published, that the would-be candidate, economic operator, does not know about it, and if no one were entitled to bring a claim, there would be absolutely no point in having that ground. However, there is a category of economic operator which can bring such a claim, and it is, under the Grossman exception, a candidate which would have wished to have participated in the tender procedure had there been one.
And can I just try to get clear in my own mind? So suppose you have an economic operator who knows nothing at all about the competition until 3 months after the contract's been awarded, and then raises the matter and is given full information within 4 months. On your case, what is the time limit?
Well, if it was given sufficient information for 93.5 to apply, then it would be 30 days after that, which would just be before the 6 months.
So even though it knew nothing about it originally, for the purposes of 55.2, it's a candidate once it knows about it.
Yes, it's 93.6 by reference to 55.2A
Yes.
in our case, yes. There is, in any event, the 6 months long stop.
Yes.
I mean, there's a balance to be struck here between the possibility of would-be tenderers being able to have their rights vindicated, their rights under the regulations, and the important principles of legal certainty. One can't have the possibility of a contract with a third-party developer at some distant point in the future being struck down, and rapidity. It is important that once tenderers or would-be candidates do have sufficient information, that they move as quickly as possible.
Yeah.
Now, the respondent's position, as we understand it, is that the language of the regulations and the nature of the reasons which are specified in Regulation 55 mean that Regulation 93.5 can only apply in circumstances where there's been a tender competition. It argues that the use of the terminology candidate and tenderer in Regulation 55.2 presupposes that there's been a competition. It is, they say, impossible for an economic operator to acquire the status of candidate or tenderer for a given contract if there's been no such call for competition. That's paragraph 11 of the skeleton. And the information to which a candidate or tenderer may become entitled to under Regulation 55.2 again presupposes the existence of a competition. That's paragraph 14 of their skeleton. The learned judge in essence accepted that argument. We argue that it's incorrect. 93.5 can apply in respect of what we call a would-be candidate in circumstances where no competition has been held. In that respect, on this first ground, there are submissions under 4 headings that we'd like to make. First of all, in relation to the language of Regulations 55.2 and 95. Secondly, the reasons under Regulation 55.2, specifically 55.2a. Thirdly, the case of Alstom Transport, which we say does assist our appeal. And fourthly, the general principle of rapidity. First of all, then, the language of Regulation 55.2 and 93.5. We say the respondent is wrong to say that the use of the term candidate, if not tenderer, which I'll put to one side, in Regulation 55.2 presupposes there's been a competition. The language used in the regulations in fact makes it clear that no competition is required. And in respect to that, we've got 4 submissions. First of all, as a matter of plain language, the definition of candidate provided in Regulation 2 clearly encompasses a candidate that has not submitted a bid or even been invited to participate. That's what we refer to as a would-be candidate. As I've already noted, Regulation 2 provides candidate means an economic operator that has sought an invitation, not necessarily received one. or has been invited to take part in a competitive procedure. So according to the plain wording of that definition, the respondent, we say on the facts, has been a candidate. In relation to the procurement of the SPA in 2012, it clearly was a candidate. It sought an invitation. It sent an expression of interest, albeit after the deadline. And it was rejected for that, and it was told the reasons for that rejection.
So just pausing there, why would being a candidate in 2012 suffice?
My Lord, it does two things. First of all, it is, of course, as a result of that competitive tender procedure that we say that we are entitled to award the SPA under the framework contract. So in a sense, albeit I accept it is a decade, it is part and parcel of the same procedure. And secondly, the respondent's attempts to be involved in a competitive tender procedure in, well, between January 2020 and ultimately July 2022 need to be seen in that prism, i.e. that they'd already tried once to take part in a competitive tender procedure, which would have led, if they were successful, to them being the chosen development partner. At the relevant time in April 2012, when that exchange in relation to the SPA took place, the relevant regulations were the public contracts regulations of 2006. They're at tab 1 in the bundle. I think it starts with the regulation which is similar to regulation 55. But it's actually the definitions which we say are important here. Under that regulations, if it's significant, my Lord, I can pass up a copy because we don't have regulations 2 and 4 there. But economic operator was defined then in regulation 4 as a contractor, a supplier, or a services provider. And a contractor, and I'll take your lordships to the wording of this, was defined in regulation 2 as a person who offers on the market work or works, and A, who sought, who seeks, or would have wished to be the person to whom a public works contract is awarded, and B, who is a national of an established and relevant state. We can see that definition from the decision in IGT at tab 21 in the authorities bundle. At page 568.
This case has actually been reported.
My Lord, it has. We
and
have,
so if you could give me the paragraph numbers,
yes.
if you can. It's in the Construction Law Reports, volume 209. And the reason that I know that is that I'm responsible for 80% of volume 209 of the Construction Law Reports. So it's a volume close to my heart.
We have copies of the report. It's actually in the PTSR as well. I think that's the copy that we produced. Unfortunately, not yet in the bundle, but we can pass it up.
But what which paragraph are you taking?
72 and 73. In 72, your lordship here, I don't know about nuggets, but this really is a tour de force of going through the stages of the EU procurement regime as it went through the directives and the implementing regulations in the UK.
So anybody struggling with sleeplessness?
The reference to the soggy biscuits kept me awake for quite some time. But your lordship arrives at the 2006 regulations, paragraph 71. And 72 says, an economic operator was defined in regulation 4 as a contractor, a supplier or services provider. Those are then separately defined in the definition section in very similar terms. I take contractors as an example. Contractor means a person who offers on the market work or works, and A, who sought, who seeks, or would have wished to be the person to whom a public works contract is awarded. The definition of suppliers and service providers uses the same formula. In my view, although this wording was slightly different to that of Article 1.3 of the Remedies Directive, which it implemented as well, this was a clear attempt to transpose what was said in Article 1.3 as to who could bring a procurement challenge. And this is important. with a slight variation to encompass what I have called the Grossman exception. The emphasis is on the entity who sought, seeks, would have wished to be the entity to whom the contract was awarded. In other words, the unsuccessful bidder in the contract in question on the facts of IGT. But clearly what your Lordship, our submission is referring to there is that the use of the phrase "or would have wished to be the person" covers someone such as in the Grossman case, or there are others, because in Grossman the tender wasn't put in because the claimant objected to the technical specifications, said that they were discriminatory and that it would never be able to cope with them. Whereas there are cases, as this case, where there simply wasn't a contract notice published at all. So at that time, the would-be tenderer didn't even know of the existence of the contract that was to be awarded. Now we say
in
the
the
respondent.
PCR 2006, they didn't have the definition. There weren't definitions of candidates and tenderers.
No, that came in after the 2014.
So this was the definition of a contractor, which they then moved away from.
Yes. But in our submission, those who are covered by the regime, both contracting authorities and those who want to bid and the rights that they're entitled to, has not actually changed. And all that is made express here is that those who would have wished to bid but weren't given an opportunity are covered, subject to some exceptions that I'll come back to. And that therefore the term economic the term economic operator and notably candidate should be read in that light. We say the respondent was an economic operator, a would-be candidate who was entitled to be informed and was so informed by a letter dated the 21st of May 2012 of the reasons why it was unsuccessful, pursuant to what was then Regulation 32(9)A of the 2006 regulations. That's at tab 1 in the authorities bundle, and the Lordships will see that it is drafted in very similar terms to what we now have in Regulation 52.
Sorry, which regulation are we on?
32(9), which is
Yes.
on page 5. Except to the extent that the contracting authority has already informed the economic operator, whether by notice or paragraph 1 or otherwise, and subject to paragraph 13, a contracting authority shall, within 15 days of the date on which it receives a request in writing from any economic operator which is unsuccessful, whether in accordance with a whole host of regulations which would amount to why it was unsuccessful, A, inform that economic operator of the reasons why it was unsuccessful, and then B and following, if the economic operator operated an admissible tender, which of course is irrelevant for our purposes. Likewise, we say, in the period between January or February
Sorry, can I just understand it? Pause on that a moment longer. Yes, I see.
In the period between January or February 2020 and July 2022, the respondents' repeated insistence that a competition should be held in relation to the development agreement plainly amounted to a seeking an invitation to compete in such a process. It's referred to the parallel market testing, for instance. The respondent was, again, a would-be candidate. Indeed, we say this, the candidate, it frankly admits in its own skeleton argument in the core bundle at tab 3, page 26, I think it's paragraph 1. we say 1, 2, 3, 4, 5 lines down. The respondent, Brookhouse, is the owner of related land and would have had an interest in bidding for the DA.
And I'm afraid I wasn't keeping up again.
I'm sorry, my lord.
Which paragraph, the skeleton was that?
It's paragraph 1, page 26, tab 3 of the call paper.
Yes. Yes.
That was the other assumption that I thought we would be making for the purposes of this. That they would have had an interest in being involved in some way in a competition. If their case is right, that this contract was covered by the public contract regulation.
If they hadn't, my lords, and this I'll come on to, they will surely have problems from a standing point of view.
Yeah.
Now, we submit that the term candidate, for the purposes of the 2015 regulations, includes in relation to a potential public works contract, a person who offers on the market works and sought, seeks or would have wished to be the person to whom the public works contract is awarded. Although that's a definition taken from the 26 regulations, it has in our submission in practice not changed since then, despite the slight change in wording in what is now regulation 2 of the 2015 regulations. And who sought in our submission needs to be understood in that light. Secondly, then, we say the fact that the term candidate encompasses what we call would-be candidates was confirmed in your lordship's decision of IG.
Well, hang on a minute, are they candidates or would-be candidates?
Well, my lord, our submission as a matter of law is that they are candidates. I use the term would-be candidate,
Because they sought an invitation.
or would have wished. Yes, they sought an invitation, they would have wished to participate, but they did not successfully do so.
Just looking at the definition again. So you say an economic operator, tick, that has sought an invitation to take part in whatever kind of procedure it would have been. Yes, I see.
Yes, we say that it covers someone who would have sought an invitation had they known about the competition, or had they known rather that a contract was going to be awarded.
Well, they're different though, aren't they? One is factual and one is hypothetical. That's why I asked. Your submission covers both. Is this right? Your primary submission is that they're a candidate because they sought an invitation, but you say if that's wrong, they are a would-be candidate because they would have sought an invitation.
Yes, on the facts of this case, of course, they knew sometime back in relation to the 2022 award that there was not going to be a competitive tender, and that therefore an award was going to be made directly under the SPA.
But as I understand it, what you're saying is they were trying to get a competition in which they would undoubtedly have tendered, and therefore
Yes.
they are within the definition of candidate because they were seeking an invitation to take part in a procedure which they say should have taken place.
My lord, yes.
That's your case.
Now, the judgment in ICT is tab 21 in the authorities bundle.
So sorry, just for my notes, you're now moving on to the second point. You said there were 4 points
Yes.
on the language, and this is the second of them.
Second, sorry, these are under the first issue, the language of the regulations 55 and.
Yeah, and you've got 4
This is the
points.
second, that's right.
And you made the first point about the candidate, and so this is your second point.
Second point, praying in aid the decision in IGT. Can I summarise it perhaps for your lordship's colleagues that the judgment It concerned the issue of standing in relation to the concession contracts regulations of 2016. We say nothing in particular terms on that. The judgment concerned a procurement challenge arising out of the competition for the 4th licence to run the National Lottery. The court considered a preliminary issue designed to resolve the question of the standing of what were called the IGT claimants. I think there were 4 of them. The defendant and the interested parties, the winner essentially, maintained that because IGT did not bid for the 4th licence, they were instead at best subcontractors to one of the unsuccessful bidders, that they did not have standing to bring the claim. And that's paragraph 1 of the decision. In your Lordship's judgment, you provided a detailed analysis of the meaning of economic operator. The judgment noted that the term economic operator was divided between candidates who had sought an invitation or had been invited to take part in the restricted procedure, and a tenderer who submitted a tender. No,
And where
that's
do you find that?
paragraph 89 in the judgment.
We're getting quite some way away from your skeleton argument, Mr. Williams, aren't we?
The
You
skeleton
were
doesn't.
quite dismissive of IGT, paragraph 38 and 39 of your skeleton. So I had rather assumed that IGT was a dead duck.
Well, I think the reason that neither party centred on IGT at the first instance was we were both of the view that it was a case that just concerned standing. But given the reasons given for granting permission by this court, it clearly needed to be looked at again. At that point, of course, we'd already put in our skeleton.
You're right, your skeleton argument is 26th of April 2024.
Permission was in March.
Yeah.
But we.
I mean, that is, I'm a bit surprised.
I entirely accept the skeleton does not go into any detail on this judgment.
So you've taken us to 89 where I'm dealing with the PCR 15. Yeah. And the whole point about IGT was that the people who'd submitted the tender were no longer in the case. And it was a whole load of subcontractors, subcontractors, subcontractors. And the question was whether they had a right to make a claim, and I concluded they didn't.
Well, yes.
So we weren't in a hypothetical type of situation. Moreover, nobody in that case was saying they were candidates, let alone tenderers.
No, but what this judgment does demonstrate clearly is that parties can have standing even though they were not, they did not submit a tender. I'm pretty sure we're not talking about subcontractors here. The submission is that your Lordship runs through detailed interpretation of the terms economic operator. You held that on a proper definition, a proper interpretation of that expression, unsuccessful bidders have standing, whereas subject to the Grossman exception, those who did not make a bid do not. Yeah. Of course, in the definition of economic operator, the word bidder isn't used, and it's clearly that that's a term which is meant to cover both candidates and tenderers. So it's not, in order to bring a claim, it's not sufficient to be an economic operator. To have standing, a party must come within one of the subsets of economic operator. And those subsets who have standing, as they will have participated or will have wished to participate in making a bid, is set out more clearly. Perhaps I can take the logic of the paragraph in the context of the concessions directive. That's paragraph 148. Where you talk about candidates, tenderers, and concessionaires, of course, relevant for the concessions contract regulations. 148, fourth line, those categories are then transposed into the definitions of Regulation 2 of the 2016 regulations. A candidate is an economic operator that has sought an invitation or been invited to take part in the concession contract award procedure. And you're going to find that none of the claimants in the IGC case fell into that category. However, our submission is that that doesn't mean that an economic operator even has to be invited to participate to qualify. And so it doesn't rule out what we refer to as would-be candidates or would-be tenderers. Because the Grossman exception, that's expressions taken from the case of Grossman Air Services against the Republic of Austria, case C-230 of 2002, decided by the Court of Justice, provides that in exceptional circumstances, such as the impossibility of submitting a tender, a bidder that did not in fact submit a tender, or even expressed an interest in submitting a tender, can have standing to challenge a procurement. Now the relevant CJEU case law is summarised in IGT at paragraphs 41 to 45.
Sorry, 41 to 45 of IGT.
IGT. So the CJEU case law confirms that interpretation. Thus, in Grossman Air Service, the claimant Grossman did not submit a bid but challenged the outcome of a procurement for air transport services on the basis the procurement documents had been biased towards the winning bidder. The question was whether Grossman had standing to bring proceedings. The CJEU agreed with the Commission's general submission that participation in a contract or procedure may validly constitute a condition that must be fulfilled before a person can show an interest in obtaining a contract. And if that claimant has not submitted a tender, it would be difficult to show it had an interest in challenging the decision. However, the CJEU recognised that there might be exceptions to that rule, namely someone who wanted to bid but could not do so as a result of discriminatory specifications in the tender documents themselves, which specifically prevented them from providing all the services requested. It was said that such a person could seek a review of those specifications at an early stage and would not be forced to submit a tender simply in order to have necessary standing. Thus, it was not black and white. Although those who had not bid probably had no standing, there might be exceptional circumstances in which they would. It is noted that although Grossman fell into that exception, the claim was still not permitted because they had not challenged the tender documents at the appropriate time. The approach, 44, the approach in Grossman was confirmed in Amt Aziende Trasporti against ATP Liguria. Again, Amt did not submit a tender but challenged the invitation to tender. The court referred to Grossman and stated that participation in the tender procedure may validly be required before an entity can show an interest in obtaining a contract, but there might be exceptional circumstances which would justify a claim, such as the impossibility of submitting a tender. And 45, accordingly, the CJEU case law makes plain that the only person withstanding to challenge a public procurement is the unsuccessful bidders. That is subject to the sort of limited exception discussed in Grossman and Amt, although prior to the hearing there was no suggestion that any such exception applied in the present case. A point did arise in relation to one of the claimants. And then further down, in reference to the case of Word Perfect, is the Ministry of Public Expenditure and Reform, that's paragraph 49, my lords. This is an analysis of other case law, and here we're looking at case law in Ireland. In Word Perfect, the Irish Court of Appeal considered both the CJEU and the Irish decisions. The Irish Court of Appeal said that because there was nothing in the tender document which prevented Word Perfect from submitting a bid, their failure to do so meant that they did not have standing to challenge the procurement. They said at paragraphs 177 and 178, in summary, I've concluded that the judge was correct in his interpretation of Regulation 4 of the Remedies Regulations, which he derived from a well-established line of authority from the CJEU, including cases such as Grossman, as applied by the High Court, Mr. Justice Hogan in Copymore No. 1, and a number of subsequent judgments of the High Courts, most recently by the CJEU in Amt. The judge was, in my view, correct to find that in general, in order to be an eligible person within the meaning of that term in Regulation 4, in the sense of having an interest in obtaining the contract at issue in the public procurement tender procedure and alleging harm or risk of harm by the alleged infringement of EU contract law, the applicant must have participated in the particular tender procedure by submitting a tender. That general principle or rule is subject to exceptions, the categories of which are not closed, but include where it was not possible for the applicant to put in a tender for various reasons, including, but not limited to, where the tender procedure was not properly advertised, and then also by reason of alleged discriminatory specifications. And of course, that is precisely our case here on the claimant's claim that this tender procedure for the award of the development agreement was not properly advertised. And finally, in relation to IGT, at paragraphs 165 to 166, there was some domestic case law and the case of Consultant Connect. 165, in Consultant Connect against NHS Bath, it was held that there was no limited prohibition on a tenderer who was not a party to a framework challenging an unlawful award made through that route. CC were the incumbent provider, but they were not a party to the framework agreement, so were not invited to tender and did not learn of the competition until their existing contract was not extended. Mr. Justice Carr said at paragraph 146, there could be no legal bar or lack of standing to claim merely because the claimant was not a member of the relevant framework. The CC submitted. If the contracting authority unlawfully awarded a contract to a framework member, the class of persons entitled to sue is delineated with the language of Regulation 91(1), and on the facts included CC. Otherwise, a contracting authority could pit two members of different frameworks against each other in a biased, unfair and skewed competition, and neither would have standing to bring a claim. My Lord, in a way, that is our case. Where it wasn't a framework agreement, but under a framework, the council decided to award a direct contract to EWG, and the respondent, not being on that framework, not being one of the partnership, partnering developers, was not in a position to bid. But nevertheless, clearly, this confirms would have standing to challenge that decision. So, Your Lordship then goes on to say, in this way, Consultant Connect was not connected with the legal position of subcontractors and so forth. And then further on in 166, furthermore, the defendant in Consultant Connect expressly accepted that CC constituted an economic operator for the purposes of the 2015 regulations. But the reason for that was because of the discriminatory way in which the entire procurement competition was run. CC were not in the framework, so did not even know they were being excluded from the competition in respect of the services they currently provided. As I observed during oral argument, although Grossman was not cited to the judge, it is quite possible to refer his judgment as fitting neatly into the Grossman exception. Mr. Moser did not dissent from that proposition. On analysis, therefore, Consultant Connect does not help IGT. But what it does confirm is that on our case, yes, the respondent has standing to bring this claim, but by the same token, that's because it is a would-be candidate, would have wished to participate in the competitive procurement, which was not in fact held.
Could I just share my ignorance of the context a little? So I've understood, which I'm afraid I hadn't understood before, under the 2006 regulations, you had a definition of contractor, but you didn't have definitions of candidate or tenderer.
My Lord, I'm so sorry to rise, but I'll show you it. But there is actually a definition of candidate and tenderer in the 2006 regulations. So my inference is not right.
I see, yes.
I'll come to it, but
It's
it's not in the definition section. It's in,
Well, it's regulation 4 then.
it's in regulation 32 of the
two.
TCRs 2006, which is tab 1, and the authority, the page number in the authorities bundle is tab 7. It's got,
So
I
sorry,
think
so-
because it's in one of the regulations,
I see,
it's probably got more limited purpose, but it's not right that there wasn't. I thought I'd just better say that now rather
Yes,
than
I
go off
see.
on a run.
which probably means that this question is the more misconceived. I was inferring that the change might have been driven by something that had happened at the European level. And certainly looking at the 2014 directive, you find candidate and tenderer. Do you find that in the earlier directive?
Well,
It is direct, but-
it's not in the same way in the definitions section. I mean, my lord, I think it's fair to say, and this comes out of what might be called the travaux préparatoires in relation to both the directives and ultimately the regulations, that back in 2006, the United Kingdom government wanted to be more helpful in the implementation of the directive by expressing what it understood in domestic terms the terminology was meant to say, whereas by 2015, I think it had got fed up with being challenged over some of this. It decided, and it says this in the explanatory memorandum, to simply copy out, not gold plate, which was one of the issues in the IGT case, but simply copy out the directive, which is why we find by 2015 the terminology is almost identical. They use almost word for word, and indeed sometimes even the regulation numbers are the same as the article numbers, although that must be coincidence.
So the 2016 regulations are very much modelled on the 2014 directive. And therefore, presumably, the 2014 directive has definitions of candidate and tenderer.
Yes.
And have we got them in what we've got here?
Don't know if you've got the definitions.
I think we only. Well, sorry, did your lordship say the directives? Because we only have the remedies directive and directive 2014-24, which is the public sector directive.
In that case, let me show my ignorance again. So the public contracts regulations we're concerned with are modelled on which directive?
Directive 2014-24. Yeah, the 15. Sorry, the 2015 regulations.
Yes.
The public sector regulations. Yes.
They're modelled on 2014-24.
24. 2014-23 is concessions.
I see, yes. So that's what we've got a little of at tab 4.
That's right, my lord, yeah.
And so presumably that directive has the definition of candidate and the definition of tenderer.
There is, again, some assistance given in this in IGT, where through all the stages, it may not be regulation 32, but the definitions are followed through, going all the way back, I think, to 2006.
So at any rate, one would expect candidate to have the same meaning. I'm not sure this is going to help, but one would expect candidate in the 2015 regulations to mean the same as it means in the directive.
My lord, yes, and I think it's common ground between us that the regulations do correctly implement the
Yes,
directive. The submission I'm making is that the meanings have not in fact changed, albeit that the language in the directive may have changed slightly, and more importantly, the UK has decided to implement in a slightly different way.
To avoid the possibility of discrepancy and therefore argument about that. Yes, I see.
Just for completeness, the candidate, for example, under the 2006 regulations, that all arises in relation to information about contract award procedures.
Yeah.
The definition of candidate, which we have, for instance, at page 7, that's a definition for the purpose of this regulation singular, which is regulation 32, information about contract award procedure. Which is why it was irrelevant in IGT, because we were considering standing in IGT, which is why we were looking at the definition of contractor, which is where you get would have wished.
And I assume, tell me that this isn't common ground, that we would expect the definition of candidate as we now find it in the 2015 regulations to be driven by the directive and not by whatever it might have meant back in the 2006 regulations, since the 2015 regulations are modelled on the directive and not on the 2006 regulations.
Well, that's correct, but we still maintain that the group of economic operators who would be entitled to bring a claim or would be entitled to seek information in relation to award has not changed.
No, I understand that, and therefore this is probably a complete red herring, but I'd like to understand the context.
I accept that.
I hesitate to rise, but I just hope it might be just helpful to know it. I told you about the definitions of candidate and tender in Regulation 32 of the 2006 regs. You also see the same thing in the Regulation 33 of the Utilities Regulations 2006, which are in tab 2. It's page 16. If you want it's the same. But those regulations, so 32 of the PCRs and 33 of the UCRs, are the direct analogue, if you like, of 55 in the new regulations. It may be helpful to know that.
Yes.
Sorry to forgive me if that was an inappropriate.
No, thank you.
I don't think that will be contested.
But I think that's right. The UCRs are in the bundle because those were the regulations at issue in the Alston case, which I'm going to come to. So, in other words, we say a would-be candidate that has been prevented from submitting a bid can have standing. On the respondent's case, that is exactly the position it found itself in. The respondent's complaint, in essence, is that it has been prevented from bidding for the development agreement by the appellant's use of the SPA instead of holding a further competitive tender procedure. It is therefore incorrect to state, we say, as the respondent does, and I think in paragraph 11 of its skeleton, that it's impossible for any economic operator to acquire the status of candidate for a given contract if there's been no call for competition. Therefore, we say, the respondent's position actually places it in the horns of a dilemma. On the one hand, if it maintains that only parties that in fact submitted a bid in a competition can come within the meaning of tender or candidate, the consequences would be that it doesn't actually have standing to pursue its claim. Based on the authorities, however, that's not the position that the appellant takes. On the other hand, if, in line with IGT, it accepts that a would-be candidate can have standing by virtue of the Grossman exception, then it follows, we say, that ground one of the appeal should succeed because the respondent was a candidate within the meanings of Regulations 2 and 55(2)A, and therefore was in that subcategory of economic operator for the purposes of Regulation 93(5) and 6, which therefore do apply. Accordingly, we say, in the light of IGT, the respondent's position is actually untenable. Indeed, if the respondent were correct and a competition in which an economic operator had actually participated needed to have been held in order for a party to be a candidate, so there are some illogical consequences that follow from that. First of all, as my lord has already said, a party seeking a declaration on the first ground of ineffectiveness would never have standing. By definition, there will not have been a tender competition whenever a declaration on that ground is sought. By the very existence of that first ground, in I think it's Regulation 1992, that can't be the correct interpretation. Secondly, where a party by its own error fails to take part in a procurement process, it will be in a better position in terms of limitation than a party that did take part, but was informed that it had been unsuccessful and given a summary of the reasons why. And thirdly, an aggrieved party that did take part in a procurement process could simply circumvent the 30-day limitation period under Regulation 93(5) by bringing a challenge in the name of a connected company that was not party to the process and allege that that party for some reason had been prevented from taking part. Now, the respondent's response to the latter of those, the latter two of those consequences during oral argument in the first instance hearing was that that would not arise in practice because such parties would not have standing to bring a claim. But as we've just seen, that is incorrect. The parties in those scenarios would most plausibly have standing by virtue of the Grossman exception. And tellingly, the respondent does not pursue that submission as we understand it from its skeleton argument of this appeal. We'll hear an oral argument.
You're getting a long way from the skeleton arguments. That's why I referred to IGT.
thirdly, we say the respondent's position fails to take account of the wider wording of Regulation 93. The crucial inclusion of the words would have in Regulation 93.6 makes clear that what is envisaged by the regulation is a hypothetical consideration of what reasons a party would have received had they made a request under Regulation 55. So, in other words, Regulation 93.6 refers to Regulation 55 for the meaning of relevant reasons only, i.e. the content of the reasons that have to be provided. It does not seek to confine, as the learned deputy judge found, Regulation 93.5 to situations where there has fact been such a competition and such a request.
That seems a different submission. Maybe I'm misunderstanding. I'd have assumed that that was an alternative submission to saying that Brookhouse was a candidate.
Well, my lord, it's very closely aligned. One of the reasons the judge found the way he did was that he found that the reasons that were provided could not amount to reasons for the purposes of Regulation 55, whereas we say that's the wrong way of looking at it. One has to imagine what reasons, had they made a request, they would have received in the circumstances. They would have been told, as they were, that the development agreement had been awarded, been entered into, and they would have been told, as they were, that they were not entitled to participate in the competitive tender procedure because there hadn't been one, there wasn't going to be one, and the reasons why that was justified. And those reasons are entirely legitimate reasons. It would be ridiculous to suppose that the council should have given reasons that purported to refer to a competition which hadn't taken place. Those were the real, correct and true reasons. And in our submission, Regulation 55 is wide enough to cover those reasons if they are the correct reasons.
Isn't this where your point about them being a would-be candidate comes in? Because if it's the reasons which the economic operator would have been entitled to receive if they had been a candidate, then under 55(2)(a) they would have been entitled to receive the reasons for the rejection of its request to participate.
Well, yes.
So isn't Muddle correct to say this is an alternative argument? You dealt with the argument that they were a candidate, and this argument is, well, if they weren't a candidate in fact, they were a hypothetical candidate if they'd known about it, and then they would have been entitled to the reasons under 55(2)(a).
Well, yes, as a what I've called a would-be candidate,
Yes.
someone who would have wished to have been awarded the contract. Yes.
Well,
I
you
take
you don't need the would have wished for that, because, as you say, that it's the reasons that they would have been entitled to receive. So the hypothesis is built in at 93.6.
My lord, yes.
Yeah. Okay.
What we say is that it doesn't seek to confine 93.5 to situations where there in fact has been a competition and a request. That's something we say that the judge clearly failed to recognise in the use of his language. In the core bundle at tab 7, we have his judgment. This is paragraph 30 at page 97. And he says the shorter time limit in Regulation 93.2a will apply where A, Regulation 93.3 applies, which is irrelevant. B, Regulation 93.5 applies, which means the economic operator has been given reasons, not only the conclusion of a contract, but also the relevant reasons. Then C, these can only be by virtue of 93.6, the reason to which the economic operator was entitled under Regulation 55. And he clearly completely fails to recognise the hypothetical situation that the use of the tense would have been in Regulation 93.6. And that must surely have then led the learned judge into error in paragraph 33D, where he then says Regulation 55 only applies where a contract has been awarded pursuant to a competitive tender procedure in accordance with the PCR, so as to engage the obligation on the contracting authority under Regulation 55.1. 55.1 is all to do with the provision of reasons, even without a request, to those who participate, and is of course not referred to in Regulation 93.6 in any event. So what we say is that the respondent's insistence that Regulation 93.5 can only apply to economic operators who have taken part in the competition confuses the scope of recipient of the relevant information with the adequacy of the content of that information. The fourth point we wish to make under this heading is that even if Regulation 93 were found to be ambiguous in this regard, we are given some assistance by the new Procurement Act 2023, which provides pervasive authority for the proposition that Regulation 93.5 can apply in circumstances where there has not been a competition. My Lord, I think it's accepted that it's well established that where the legal meaning of an enactment is doubtful, subsequent legislation on the same subject may be relied on as pervasive authority.
A little bit more dodgy than that, I'd have thought.
Well,
Even if you look, I know someone cites DSG, and it's all rather more tentative.
well, we've set out the proposition, I think, in paragraph 28 of our skeleton.
And issue was taken with it by the respondent.
Speaking entirely for myself, I would be very reluctant to make any sort of pronouncement on the meaning of the 2003 Act. A, because it's deeply controversial. B, because I don't think it's yet the subject of any authority.
Well, my Lord, I guess that must be the case, as it's not actually in force. But, well, may I make my submissions in relation to the Act, and we can see where we go. I mean, my primary submission is that it is not actually, there is no actual ambiguity in relation to the interpretation of Regulation 93.5 and 6. So I agree, therefore, it will be improper to look at the Act. But nevertheless, the general time limits and the special time limits in respect of a declaration of ineffectiveness under the 2015 regulations are now reproduced, not in identical form, but are now reproduced in section 106 of the 2023 Act. That's at the tab 6 of the authorities bundle. We thus see at 106, 106 is at page 102. A supplier must commence any specified set-aside proceedings before the earlier of A, the end of the period of 30 days beginning with the day on which the supplier first knew or ought to have known about the circumstances giving rise to the claim, or B, the end of the period of 6 months beginning with the day the contract was entered into or modified. There's then in 106.2 time limit for all other proceedings. We say that it's clear from that wording that Parliament has proceeded on the basis that what matters, even in the context of the special time limits for what's now called a set-aside order, i.e. what used to be a declaration, or what is now a declaration of ineffectiveness, but will cease to be in October, is when an economic operator has the requisite knowledge to bring a claim. Notably, there's no longer specific reference to an economic operator being provided with a summary of the relevant reasons for the purposes of a previous competitive tender procedure. So clearly no such competition is necessary for time to start to run. What matters is knowledge.
But
Arguably,
that's the general point under the 2015 regulations, because that's regulation 92.2.
Two, yes.
So what's happened is they have streamlined the time limits. So instead of having 2 lots, they've just got one where they meld, possibly in not the most elegant language, but anyway, they meld the two together in 106.1, making it clear that the time limit starts to run before the earlier of those 2 dates. So 6 months then is clearly and patently a long stop, and the other is 30 days. But the 30 days is the objective test when the supplier first knew or ought to have known about the circumstances giving rise to the claim. So the relevant reasons point has gone.
Well, my lord, yes, of course, it's gone as a matter of.
But this case turns on the relevant reasons.
Yes, but the relevant reasons are, of course, reasons which are deemed to be sufficient for you to be in a position to bring a claim. You allege that there's been a breach of the regulations, and to do so quickly within 30 days. And in our submission,
That's the point of this appeal, as I understand it. But under 92.2, that would be right. The reasons are the reasons that you need in order to bring a claim. Under 93.3, 93.2, it is Brookhouse's argument that you have to look at the relevant reasons, and the relevant reasons are precisely defined. And then you go to 55.2. So that's nothing to do with the wording of when you knew you could bring a claim, they say.
but my lord, the reason that one is first of all is entitled to have reasons provided why one has been unsuccessful is so that one can check to see on a minimum of information whether there is an arguable claim that can be made for breach of the regulations by the contracting authority which made the award. And that is why, because of the importance of a declaration of ineffectiveness, the shorter time limit kicks in. Now, arguably, a summary of the relevant reasons could in fact be slightly less, I suppose, than what is now provided for in 106.2, and I agree it has been 106.1a has been aligned with 106.2, but what it emphasises is it's not the importance that there's been a competition at which the would-be challenger participated, but rather whether it participated or not, whether there was a competition or not, it has sufficient reasons in order to bring a claim against the contracting authority, and then must do so promptly.
Can I get the context again? You were just explaining that the 2015 regulations were modelled very closely on the directive because the United Kingdom didn't want to find that it had produced a discrepancy. By 2023, we were no longer in the EU. Does that inform the way in which this Act is drafted, because there's no longer the same concern to achieve exact correspondence with the directive?
Well, clearly there's no longer any need to implement any of the provisions. The UK, however, is still under international law obligations to comply with its uses of the GPA, the General Procurement Agreement. And although I entirely accept that all of these provisions have yet to be tested in the High Court, and it is sometimes very unhelpful that new terminology has been used in circumstances where even the Cabinet Office insists that there was not intended to be any change in the law, and of course there'll be parties who want to test that. In this respect, we say, the United Kingdom government has not sought fundamentally, or indeed at all, I mean there are tweaks, aren't there, but fundamentally to change the provisions in relation to the bringing of claims, and notably claims in respect of a declaration of ineffectiveness.
I've come across this problem elsewhere where you get new legislation with different wording and then a statement to Parliament that's supposed to mean the same thing. And you think, what do we do in that situation? But leave that aside for one moment. So there remains an international dimension, but there's no longer a requirement to mirror EU law precisely.
Correct.
Therefore, you can move away from the candidate, you can move away from tenderer and so on. But is that a reason for being the more cautious about taking the 2023 Act as giving guidance to what the 2015 regulations were meant to mean, because the 2015 regulations were meant to mirror EU law?
Well, I'm bound to accept that had the 2023 Act been intended to implement EU law, the point would be better made, would be stronger. But in our submission, insofar as the UK did, with the exception of the use of the phrase set aside as opposed to declaration of effectiveness, that the language does not change here. Notably in relation to all other proceedings, and you know the in relation to what's now called set aside proceedings, we still have the period of 6 months beginning with the day the contract was entered into or modified, which is effectively the same under the regulations. The two ways to achieving a 30-day time limit in respect of those sort of proceedings where declaration of effectiveness is sought under the regulations are publication of a contract notice, giving the contract award notice, giving the reasons, by which of course everyone would have knowledge or deemed knowledge, or providing those reasons specifically to a particular would-be challenger. We say somebody who by definition must be a candidate, therefore, and telling them the contract's been entered into, and these are the reasons why, on the facts of this case, there wasn't a competitive tender. And that is the knowledge which, in accordance with the current case law, notably the CETA line of authority, which would be sufficient knowledge for 30 days to begin to bring a claim. And we say it's clear, therefore, that what the UK Parliament has done is ensure that it's the provision of knowledge, sufficient knowledge, that is important, because the principle of rapidity is very, very important here, rather than whether or not the sort of argument that the respondent is making on this appeal means that because of technicality that there wasn't a competitive tender, therefore that route to 30-day short time limit is not available.
Mr. Williams, in a nutshell, and I mean a nutshell, how much further are arguments in respect of legislation which is not in force, has not yet been susceptible to any challenges in the court, to take determinations in this case?
Lady, may I take some instructions? Lady, it's not the strongest argument in relation to our first issue, and I'll pursue it no further. The second issue then is the reasons that are to be given under Regulation 55. Much is made by the respondent of the contention that the information referred to in Regulation 55 is information that cannot exist if there has not been a tender competition. That's paragraph 14 of its skeleton. We submit that information within the meaning of Regulation 55(2)A clearly can be supplied where there has not been a competition. Regulation 55(2)A relates to informing any unsuccessful candidate of the reasons for the rejection of its request to participate. Now, the respondent says that the reasons provided by the applicant, the ones we've seen in those various correspondence, cannot fall within Regulation 55(2)A because the respondent was not a candidate, i.e. what they call an economic operator who had submitted a request to participate in a restricted procedure following a call for competition, and it had not had its request to participate rejected. Now, the respondent's position, however, we say doesn't really withstand scrutiny. It is sufficient to have sought to participate, or we say even to have wished to have been the person to whom a public works contract is awarded. And the respondent did repeatedly seek to participate in a procurement procedure. It doesn't have to be any particular procedure like a restricted procedure. This, of course, had been the competitive dialogue procedure. This time there was no procedure. As already explained, the respondent submitted a request to participate in the competitive dialogue procedure for the purposes of the procurement of the SPA in 2012. It then sent repeated demands that a competition be held in respect of the development agreement. And I've taken your lordships to the, I think the relevant letters, the 13th of February, and notably the 24th of March. Those communications in our submission can't really be interpreted in any other way than request the respondent was in fact making that the appellant run a competitive procurement procedure in respect of the development agreement, so that it should be allowed to have the opportunity to participate in a further procedure, and it was therefore a candidate, we say a would-be candidate, in that it sought an invitation as per the definition of candidate in Regulation 2 to take part in a competitive tender procedure. Those requests were clearly rejected by the applicant in the sense that reasons for the rejection of its request to participate were clearly given. Again, I think I've taken to the public correspondence, possibly the letter of the 13th of March and the...
Well, we've looked at that, haven't we? We've looked at that.
I think we have, yes. Plainly, we say the case therefore does fall within Regulation 55(2)(a). The appellant does not suggest, as I've already indicated, and has never suggested that it falls within 52(b) to D, because clearly the respondent was never an actual tenderer, but it was a candidate. The third issue then is the authority of Alstom Transport. We submit that that provides further persuasive support for the proposition that Regulation 93(5) can apply in circumstances where there hasn't been a competitive tender. That decision is at tab 13 in the authorities bundle. So I can begin by saying that that concerns an application by the defendant to strike out part of the claimant's claim that sought a declaration of ineffectiveness under the Utilities Contracts Regulations of 2006. There were similar definitions of contractor in Regulations 2 and 4 of those regulations to the Public Contracts Regulations of 2006. Among other things, the defendant argued that this aspect of the claim was time barred by Regulation 45E5 of 2006 regulations, and it was assumed for the purposes of the application that the contract in respect of which the claimant sought the declaration had been materially varied following a procurement. That was important because it meant that that should have required a fresh tender competition in order to comply with the regulations. That's set out in paragraph 5 in the judgment. For the purposes of this application, a number of assumptions are made in favour of Alstom. The first is that the regulations relied on by Alstom apply, what's contested by the defendants. The second is an assumption about the contract entered into when compared with the previous tendering process. Alstom's claim is dependent on an allegation that the contract entered into by Eurostar and Siemens departs from the contract sought by the tender process to such an extent that it is a materially varied contract, which was not actually the subject of the previous tender process and would have required a fresh process in order to fall within the regulation in question. This too is assumed to be correct. Now, the claimant argued that as a result of the variation, the equivalent provision in Regulation 33(9) of the UCR 2006, the equivalent provision to Regulation 55(2), was not engaged, as no competition had in fact taken place with respect to the varied contract. That's paragraph 65. It's little Roman 2, what 1, 2, 3, 4, 5 lines down. There cannot have been a summary of reasons, because Regulation 33(9) can never have been engaged in this case, because the material alterations mean that a different tendering process was going on to that which Alstom was participating in. Regulation 33(9) in this context can only be engaged where there is the same process being conducted in relation to each tenderer. Since Alstom was tendering on one basis and Siemens was tendering on another, there was no proper process. Regulation 33(9) cannot have been engaged, so there can never have been something qualifying as a summary of Regulation 33(9) reasons. and it goes on to say whether the reasons were adequate or not. First of all, the court confirms in its decision that in relation to limitation, the summary of the relevant reasons to be provided under Regulation 45(6) was that to which Alstom would have been entitled to had a request been made under Regulation 33(9). That's at paragraph 62. If the defendants are to be successful in this part of the application, they must show that there was a relevant date within Regulation 45(e)(2). A, that it occurred more than 30 days before the claim form in action. Working through the provisions of that regulation was established the following things to arrive at the relevant date. 1, that Eurostar informed Alstom of the conclusion of the contract. 2, that the date on which it was so informed. 3, that it gave a summary of the reasons that Alstom would have been entitled to had a request been made under Regulation 33(9). And 4, the date on which that summary was given.
I'm sorry, Mr. Williams, I wasn't keeping up. Which paragraph was that?
That's paragraph 62, my lord. Which confirms that
I see, yes. Yes.
the hypothetical nature
Yes.
of the request. Now, what was argued on the assumed facts set out at paragraph 67, what the judge, Mr. Justice Mann, refers to as Ms. Hannaford's second point. Second point returns to the theme of the assumed materially altered contract. Ms. Hannaford adapts the analysis for these purposes and refers to what are in substance two tenders. She says that what actually happened on the assumed fact was that Alstom was engaged in tendering under one contract, tender A, whereas it now transpires that Siemens were tendering for another on materially different terms, tender B, on which Alstom never had an opportunity of tendering. So there was effectively a direct negotiation with Siemens under a new process, which would have started again at the beginning with Alstom properly involved. So she argued one never got as far as the reasons being given in relation to that new process under Regulation 33(9), so there could never have been a summary on those reasons either. It was impossible to fulfil the conditions of the limitation period, so it did not apply. Alstom were not and never could have been told why they were not successful in tender B because they never participated in it. Accordingly, both Alstom Transport and the present case concerned the argument that the disputed contract award required a new competition, with Regulation 55(2) in our case, Regulation 33(9) in that case, therefore being inapplicable as there had not been one. And it's the consideration of that argument, we say, that makes Alstom Transport directly analogous to the present case. As already explained, the respondent was unsuccessful in its attempt to participate in the procurement that ultimately led to the award of the development agreement. As in Alstom, the respondent argues that the original competition held cannot be relied on and that the challenge contract requires a new competition, with Regulation 55 therefore not being applicable. However, Mr. Justice Mann expressly rejected that analysis at paragraphs 68 to 70, and we say that he was right to do so, and this court should follow the same logic. 68. The validity of this point must be judged against the wording of the regulations. The starting point is the definition of relevant reasons in Regulation 45(6). That refers back to the reasons which Alstom would have been entitled to in response to request under Regulation 33(9). So one goes back to Regulation 33(9) to see how it applies. Regulation 33 is about the provision of necessary information. It applies when a decision has been made to award the contract. That contract is, in my view, the contract which the utility has been telling the relevant commercial world it is minded to enter into, and is the contract which apparently conforms to the proposed contract for which it called competition under the Regulation 16 mechanism in this case. The tenders and candidates referred to are those who were tenders and candidates for that contract. That is the effect of the definitions contained in paragraph 14. The provision of such information is a vital part of the control mechanism under the regulations. Tenders and candidates are entitled to assume that once they are part of the process, they will get the information referred to in Regulation 32. The regulation makes linguistic and commercial sense if it's construed that way. It would not make so much sense when Ms. Hannaford's construction to be correct. If she were right, then a utility which decided to award a materially varied contract, which in fact required a different tender process, would not be under any obligation under this provision to announce the award of its contract, let alone give reasons under this regulation. That would be a very curious result. The unsuccessful entities would be in the dark as to the award of any contract at all, And while that would mean that they have no right to challenge, because on the assumed facts they would have all sorts of other objections to what had gone on, they would, for a time anyway, be in the dark about most material facts, the award. It is difficult to accept that was the intention behind the regulations. It's much more likely to be its intention that the contract referred to is the contract which was apparently resulted from the previously announced procedures, and therefore, ostensibly at least, which the unsuccessful candidate and tenderers thought they were competing for. If I can go down to H, such an no, I should read it all. If it is right in relation to the announcement of Regulation 33.1, then the same chain follows through the remaining parts of the regulation. Paragraph 2 works well and intelligibly, so does paragraph 9. It applies in favour of an economic operator which was unsuccessful. It was unsuccessful in relation to the tender it submitted, in relation to the overall process it was participating in. It may be that as a matter of analysis, the eventual contract falls to be treated as a contract beyond the scope of that process, but that is no reason to go back and treat them as being two parallel processes going on at material times before then for the purposes of Regulation 33. Such an analysis would tend to make a nonsense of the provisions of Regulation 33 and paragraph 9 in particular. Paragraph 9 requires the utility to tell the unsuccessful economic operator why it was unsuccessful. That can only mean unsuccessful in relation to that which it sought success, namely the contract it was bidding for. We say, in our case, namely the contract they wanted to bid for. The identity of the successful tenderer who was awarded the contract must mean the contract that was actually awarded at the end of the process, and the successful tenderer obviously means the tenderer which was actually successful. Now, the respondent seeks to distinguish the decision in Alstom Transport on the basis that there had been a call for competition and a tender process, and that the claimant had been given reasons which purported to be relevant reasons within Regulation 33.2. That's, I think, paragraph 66 of its skeleton. However, as explained, the judge had assumed in the claimant's favour that the procurement process did not cover the contract eventually awarded. In those circumstances, it can't seriously be suggested that the only difference between the two cases was that the reasons given purported to be relevant reasons, whereas here, the reasons given by the appellant to the respondent allegedly do not. The reasons given were the absolutely correct reasons why there had been no competitive tender in which the respondent might have participated. Accordingly, we submit that Alstom Transport is really the only relevant authority which has been identified by both parties as dealing with these special time limits, directly contradicts the respondent's position that a competitive tender procedure is required in order for Regulation 93.5 to apply. My Lord, the fourth issue I want to deal with is the principle of rapidity. We say it should be emphasised that the respondent's position is inherently improbable in the light of this principle. The principle of rapidity lies at the core of the 2015 regulations, and indeed, for what it's worth, the 2023 Act, and is a central feature of the Remedies Directive. Can I refer your lordships to the case of CETA?
I accept that there's a principle of rapidity, if that helps.
Well, I'm grateful, my lord, that the general principle of rapidity is accepted, but how it applies in this case, I think is worth looking at.
How it applies in CETA.
Well, CETA, of course, was a case dealing with the general time limit. But what it says about what a tenderer needs to know, the essential reasons indicating a prima facie breach, is in our submission significant. Clearly, that is what the tenderer needs to know by virtue of having been given a summary of the reasons why the contract that he wanted to bid for was awarded. Therefore, it does have some bearing on how one should look at how the provisions under Regulation 93.5 are. It was recognised also, your lordship will recall, in IGT, citing the Grossman Air Service case. Contrary to that principle, so do your lordship want to see the relevant passages from both the CETA at first instance and in the Court of Appeal?
I suspect we don't need to. I mean, as I understand it, it's common ground that there is a principle of rapidity. Of course, that makes a great deal of sense where there's a claim for a declaration of ineffectiveness, because otherwise everyone's left in the dark. The question is how far it extends in the circumstances of Regulation 93. There's obviously the 6-month longer limit. The question is whether that longer limit applies to the circumstances of this case.
Yes, the 6-month long stop, of course, is more to do with legal certainty than rapidity. In our submission, even 6 months is quite a long time.
Yes.
It's absolutely vitally important that contracting authorities can have access to both Regulation 93.3 and 93.5 in order to achieve the shorter time limit, so that if there is to be a challenge, that can be flushed out, and if there isn't, the parties can get on with it.
And I can quite see why it may be thought desirable to have a shorter time limit.
Contrary to this principle, we say the respondent's interpretation of regulations would allow a potential claimant who has the information necessary to bring a claim, by virtue of being provided with a summary, even in our case, frankly, the detail of the relevant reasons, to decline to do so for up to 6 months after the relevant agreement was entered into. And we say that that's a far cry from ensuring the rapidity of challenges envisaged by the regulations. The respondent's response to our submissions on the principle of rapidity is that there's a complete answer to be found in Regulation 93.3 and 4, the one that I said didn't apply because a contract award notice hadn't been published. That's paragraphs 57 and 63 of their skeleton. In short, the respondent says that read together, those regulations cater for the precise situation in the present case, where there's been no competition for the contract in question. The contracting authority can issue a contract award notice to engage the 30-day time limit. And according to the respondent's case, it would be very surprising if Regulation 93.5 were to apply to the same situation, by enabling the contracting authority to engage the shorter time limit, but by an alternative route of writing to the individual economic operators, or the ones who are threatening a challenge, with a summary of the relevant reasons. We say that argument is misguided. There is in fact every logic to being able to engage the 30-day time limit without publishing a contract award notice. That's because publication of the award notice inevitably exposes the contracting authority to further possible claims from other possible challengers. Where there has not been a competition, the fact is advertised, and the authority, even if it was right not to hold a competition, is then put to the cost and expense of dealing with further potential challenges. And of course, the possible imposition of an automatic stay under Regulation 95 if it hasn't actually entered into a contract. And that, and certainly that's something that it would not otherwise have faced. In contrast, the ability to engage the 30-day time limit by providing a summary of the relevant reasons allows a contracting authority to deal specifically with any particular economic operator who has in fact contacted the contracting authority and indicated its intention to mount a challenge without making any announcement to the world at large.
We have to be slightly careful about that, though, don't we? Yeah. Because if it is a direct award, then that process would be favouring somebody who would know a bit about it, so on your case, Brookhouse, but not another contractor who didn't know anything about it. If you're saying, well, it's perfectly justified not to issue a relevant contract award notice because you don't want claims from other people, but instead you hive off the people who do know about it under 93.5, on the face of it, that sounds like a breach of procurement law, public procurement law.
My lord, no. What it does is make sure that if, use your lordship's words, that that economic operator who does know about it wishes to bring a challenge on the basis of the reasons it's given, then it needs to do so quickly. In fact, other would-be bidders would not be subject to that, and obviously that's a risk that the contracting authorities have to balance, whether it is better to flush out potential challenges because, for instance, by publishing a contract award notice, time limit, but clearly, assuming that the proper reasons are given in it, any challenge will have to be brought within 30 days, or dealing specifically with a rather vociferous would-be tenderer who has been threatening a challenge for the best part of 2 years. Similar concerns often affect the decision of a contracting authority to publish a VET notice, a voluntary ex-ante transparency notice under Regulation 93(3) and 4, which gives them protection from the remedy of a declaration of ineffectiveness. Because although it does provide that protection, by publishing the notice, one is effectively, only for a 10-day period, but inviting the potential for someone to come out of the woodwork and make a challenge. Moreover, we say against the respondent on this issue is the fact that given the draconian nature of a declaration of ineffectiveness with the serious consequences for third-party contractual rights, it is essential that the time period in which the risk of this remains should be as short as possible. In those circumstances, if the legislator, both EU and domestic, had intended that this route to the shorter 30-day time limit should not be available in these cases, in which there has been a direct award and thus no competitive tender procedure, it should and would have said so expressly in Regulation 93(5) and then the Remedies Directive, which that implements. One can look, if one looks at the regulations, at tab 5, one can contrast (93)(3) and 4. 3 provides for the where a relevant contract award notice has been published. It used to be in the official journal, now it's on the UK e-notification service. For that purpose, a contract award notice is relevant if and only if, that's making it clear that it only applies to these circumstances, prior award without publication and justification given. Whereas, in respect of Regulation 93(5) and 6, there is no corresponding only. It is not simply expressly limited to situations where there has been a competitive tender. And thus, in our submission, it should be open to a contracting authority to have that route, even if it could, in different circumstances, have gone down the route of Regulation 93(3).
So what, more permissive?
Yes. So, for those reasons, we say Regulation 93(5) can apply to would-be candidates in circumstances where there has not been a competitive tender procedure. Now turning to the grounds of appeal, if the court accepts that Regulation 93(5) can apply to what we've termed would-be candidates in circumstances where there has not been a competition, then in our submission, ground 1 must succeed. Ground 1 was that the judge was wrong to find that a contracting authority could only rely on Regulation 93(5) when a competitive tendering exercise has been carried out. The reasons to be provided in Regulation 93(5) are those that an economic operator would have been entitled to. They are not the reasons that an economic operator was in fact entitled to. The judge should have found that Regulation 93(5) can be engaged in situations in which a competitive tendering process has not been held and therefore apply to would-be candidates and tenderers. As to ground 2, that's never been seriously, or rather, the respondents never seriously contested the adequacy of the reasons that were provided to them as to why no competition was held in respect of the development agreement. Indeed, at the hearing, at first instance, of the parties' respective applications, the respondents conceded that the reasons were not insufficient in and of themselves, rather it's their case that they simply did not constitute relevant reasons for the purpose of Regulation 55. We therefore say if we succeed on ground 1, it follows that we must succeed on ground 2. Ground 2 being, having found that Regulation 93(5) of the 2050 regulations can apply in circumstances where there has not been a competitive tendering exercise, the judge should have found that a summary of the relevant reasons had been provided to the respondent and claimant. That summary does not have to be in any particular form.
There's no issue.
The required process is the passing of information the judge's view that no such reasons had been provided, expressed as we've seen briefly in paragraph 31 of his judgment, was simply wrong. Having correctly identified that a summary of the relevant reasons had been provided, the judge should have found that the claimant's claim was time barred. However, for the sake of completeness, I am happy to run through the.
My lord, there's never been any issue about this, and I don't actually think there's a finding by the judge about it. I've never understood what ground 2 is,
I
but
think the finding by the judge, he does refer to the word sufficient.
yeah, but sufficient, it's in the, well, let's have a look. But
I mean, I think that was the only point that I thought was live in ground 2 that was different to ground 1, but the judge doesn't further elucidate on that. I'm going to find it.
remind myself, if it's helpful, I just, because I'm conscious of time, so I'll just turn it up. But I don't think there's an issue between us about it at all. I don't think, I had not read the judgment as being,
As I read the judgment, I'm dealing now with paragraph 31.
Yeah.
It's linking the reasons to regulation 55.
exactly, he's not making a separate,
He's making no
Exa-
separate
exactly.
finding.
respectfully agree. So there is no ground 2, I think.
So if it were relevant, I quite
Yeah, yeah.
appreciate that you
Yeah.
say it isn't.
Yeah.
But if it were relevant that we were in CETA
Yeah.
territory, you don't say that in terms of sufficiency of reason.
I'm not saying there's a freestanding point about the adequacy of the reasons. I mean,
you-
if they're the kind of reasons that 93.5 contemplates, I'm not saying they weren't detailed enough. Indeed, they were very detailed, as my learned friend has said. I mean,
Yeah.
there's never
so
made,
there's,
no,
so there's no
never
separate issue
There's no separate
about adequacy or
and
sufficiency
there never
of
has
reasons.
been.
Well,
Yeah.
that
But
fine,
anyway, there's
but
none now,
You
yeah.
say it comes back to the same point.
Yeah, it's all back to the same point, and we've said that in the skeleton. I don't know if that helps. I don't know if that.
Well, it probably does, my lord. The submissions that I was going to make, I'm also conscious of the time.
Yes, I'm just trying to work out whether we break now or whether we hang on a moment.
Were in relation not to CETA, but to what was said by the court in Alstom Transport. But in light of what my learned friend said, it may not be necessary
No.
even to go there.
So on that basis, essentially it's your ground 1, and as I understand it, you've made your submissions on
My lord,
ground
I have.
1. So is that your case?
It is, my lord.
That's very helpful, thank you very much.
Well, just before you rise,
Yes.
there was a discussion about the fact you don't have the definitions of candidate and tender in the directive.
Yes.
We've got them in the meantime.
Yep.
I mean, they are the same as in the regs, but if you want the relevant bit of the directive, we can hand them up. And if you don't want them and don't want to be burning the paper, that's fine by me. I've no particular-
I think just to understand the context better,
Let's
that
hand
would
them,
be
let's give them
helpful,
to you.
please.
So I've got
So
3
these
copies
will
and
go
we'll just,
into tab 4.
I think that's a sensible place, yeah. Exactly. I think it's tab 4, let me just turn it up, but I believe it's tab
It's the 2014-24.
Yeah, exactly. That's right. Yeah, and probably before because there are earlier provisions in the bits we've already got. You see what I mean?
Yep.
Thank you. So
Of
I
the
hope that's-
directive.
Yeah. Yeah, so you've
Oh,
got
well,
the
the
definitions of candidate and tender in the
First page
regulations.
is
It's the very first page of the directive.
cited.
It's just for the purpose of
Very
seeing what it is, I think. And then the bit you've got. Oh, wait a minute.
I see, yes.
Yeah, the bit you've got is Article 55, which corresponds to Reg 55. The bit you've now got in addition are the definitions which correspond to the definitions in the regulations.
Yes,
So
that's
that's,
That's very helpful. 5 past 2?
fine.